Hi everyone, it's Lauren here from ConLaw. It's now about to turn 5 o'clock on Friday the 14th of March 2025. And before the weekend, I wanted to check in with a podcast for you all on a judgment that I've just read, which I found to be quite interesting. In the main, also because it adopts the proposed factorial assessment that myself and my co-author set out in an article that was written and published in 2020 entitled "The Quest for Reasonable Certainty, Refining the Justice and Equity Remedial Framework in Public Procurement Cases." And that is 2020, volume 137 of the South African Law Journal, and it commences at page 559. Now, as you know, when it comes to granting orders pursuant to judicial reviews, and in general, our courts have a very wide remedial discretion. So at the level of remedy, the scope for judicial intervention is rather expansive. If you therefore look, for example, at section 172 of the Constitution, which is largely echoed in the PAJA, the Promotion of Administrative Justice Act, section 172 states the following. This is obviously in the chapter on the courts. It states that the powers of courts in constitutional matters, so this is in relation to constitutional matters, which these days almost everything is a constitutional matter. The Constitution, as you know, applying both on the vertical plane and horizontally insofar as is applicable in accordance with section 8. When deciding a constitutional matter within its power, a court A must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of the inconsistency. What does that flow from? That flows from, number one, the founding value in our Constitution, which states that the Constitution is supreme, and therefore all law and conduct must be consistent with it. In addition thereto, insofar as law and or conduct is not consistent with it, the courts have to declare it to be invalid, and in accordance with the doctrine of objective constitutional invalidity, the default approach is that such declaration will render that impugned action, conduct, act, etc. invalid, as if it never existed, void, and therefore all ensuing acts that were taken in reliance on that piece of law, that conduct, would equally be invalid. That is the default proposition based on supremacy of the Constitution, the rule of law, the court's place, indeed, within the separation of powers as the ultimate guardians of our sovereign or supreme Constitution, and the doctrine of objective constitutional invalidity. I have previously done a podcast on eau de Crawl and how, of course, the eau de Crawl principle is used, particularly in the context of collateral challenges, which I've discussed, and I'm not going to do so now. But I want to talk about the gloss provided within our Constitution to this basic default position. So section 172b then states that the court may make any order that is just and equitable. And this can include an order that limits the retrospective effect of the declaration of invalidity. So remember, it must declare it to be invalid, right? It is invalid. If it's inconsistent with the Constitution, the court finds as much, it is invalid and it must be declared as such. But the court can say, my goodness, for example, if a marriage officer was a fraud, was unlawfully appointed and officiated various marriages, it would be catastrophic were all of those unions and the children born of those unions to be adversely affected by such declaration of invalidity, and therefore the court would presumably limit the retrospective effect of that order, thereby softening its prejudice, its implications, when at the level of impact. It may also suspend the declaration of invalidity, and this is very common when particularly the courts are dealing with reviews or challenges to legislation. They will often give the legislature a chance to remedy the defect, or for example, where state housing programs, plans, policies, conduct, socioeconomic rights related considerations are challenged. Often the courts have historically said, go back to the drawing board, engage meaningfully with the impacted stakeholders, and then report back to court. It's almost in the nature of a structural interdict, but that meaningful engagement order is basically a way of saying we're going to suspend a finding of invalidity, we're going to give you a chance to fix things, right? And that in itself represents respect for the empowerment and positionality of the other organs of state within the separation of powers, branches of state at least. Okay, so the court may suspend the declaration of invalidity. This may be done for any period and on any conditions to allow the competent authority to correct the defect. Okay, so that's called the corrective principle, which you may have seen mentioned in that seminal duo of judgments penned by Justice Frydenman formerly of our Constitutional Court, a tremendous man and jurist, in the all pay judgments, which flow from preceding thereto were the cash paymaster judgments, and again flowing therefrom were the black sash judgments, and all of these were really, it's a really important set of jurisprudence dealing with the court's remedial powers and also the court's powers when it comes to review on the merits, right? The merits of a review application and the process to be followed in relation thereto. And in the all pay case, Justice Frydenman sets out what he calls the so-called two-stage approach, right? We deal first, of course, with the merits, and then we deal with the matter of remedy. Then, of course, there was this judgment, which, and I still remember when it was handed down, and I was lecturing at the time, everyone was abuzz on their phones on Twitter, and this is the so-called judgment of Gajima versus Sita. And in this peculiar piece of Constitutional Court reasoning, essentially what the court held was that when it comes to the review of administrative action by organs of state themselves, which has frequently, of course, been done, that must be done not by way of the Paja, notwithstanding the wording in the Constitution that the Paja gives effect to the right, notwithstanding past precedent to the effect that it's always gone through the Paja, notwithstanding the principle of subsidiarity and the principle of avoidance, which requires, of course, the principle of subsidiarity, the legislation passed by a democratically elected parliament gives specificity and legitimacy and clarity and bite, substantive bite, to the relevant right in question, and that therefore one ought not to go behind that to the right, save in certain instances, but rather follow the process set out in the specific legislation. So that was, of course, always the intended plan, irrespective of the identity of the party seeking to review and set aside, or whatever it may be, the administrative action as defined in question. Now, when the Gajima judgment was handed down, there was a peculiar line in the judgment, Sita versus Gajima, Sita being the State Information Technology Agency, about the rights only being available to warm-bodied human beings. Now, this in and of itself is a strange statement because we know that the Constitution itself says in Section 8 that the Bill of Rights applies both in terms of its duties and its rights, not only to natural, warm-bodied human beings, but also to juristic persons, bearing in mind the nature of the right and the corresponding duty. So as alluded to previously, juristic entities enjoy the right to freedom of expression. They also enjoy the right not to be defamed, etc., to have their inherent, their commercial reputation protected, right? So it is very peculiar that this came about. And of course, the court backpedals on this quite substantially in ensuing jurisprudence, trying to carve out a way around its own, I suppose, misstep, one might say. Now, in a chapter that I wrote, which may be of use widely across Africa, it's in a book called Pursuing Good Governance in Africa, and my chapter, which was co-authored with Hugh Corder, is Chapter 7, Administrative Justice in South Africa, an overview of our curious hybrid. And this came out quite recently. It is a CAS publication by the Konrad Adenauer Stiftung. It is available freely online, and it was quite something, attempting to summarize our South African system of administrative law in relatively few pages. But insofar as you're interested, I suggest it's a worthy read. It's relatively up to date. It starts at page 120 and concludes on page 150. So it's pretty pages, and it's really not that onerous. And my main goal in constructing this particular piece at the time was to to do so around the various, what Cora Hoekstra calls pathways to review. I think perhaps it's more accurate these days to call them, as I say, routes to redress, because it's not always a review that one is seeking. There are other ways to get reparations, to vindicate rights, so it's not necessarily even by way of a review. And if you have a look at pages 139 to 140 of this particular chapter, you'll see that the following is stated. The temptation, and I've spoken to you previously in one of my recent podcasts regarding the burgeoning that I anticipated of the principle of legality and rationality, and in particular what interested me was its impact on the separation of powers. Because of course, you know, the PAJA is the legislation drafted by a democratically elected parliament that seeks to give effect to the bundle of Section 33 administrative justice rights. So it's not so much a matter of confusion, proliferation, subsidiarity. More fundamentally even, it's the fact that we are sidestepping what our democratically elected parliament intended be the appropriate route to redress when it comes to challenges to administrative action. That was not sufficiently hammered home in the literature at the time, and I found that to be particularly disconcerting, and that is what I therefore addressed in my LLM dissertation and the article that I discussed the other night. In this more recent chapter, in discussing the various pathways to review and their continued proliferation, or routes to redress, as I've called them, at page 139 to page 140, if you would allow me to quote my own words here, in this particular case, the temptation of legality's suppleness and more forgiving procedural requirements, as opposed to the PAJA, right, which has set procedural hurdles, fixed specified numbers of days. It has also the disconcerting and just disingenuous practical result of enabling organs of state to rest on their laurels and invoke legality to review their own decisions, seemingly when they no longer suit, without being hit by the PAJA's restrictive time bar provisions. So those are the delay rules. This is epitomized by the notorious case of Gachima, which has been alluded to above, and pursuant to which we now have, again, as I said, an additional, in this case I call it, doorway to legality review. But now, rather bizarrely, instead of it being for public power that falls outside the remit of admin action, it's for administrative action itself. However, administrative action proper, but when challenged by an organ of state, which took it. In a curious piece of judicial reasoning, the Constitutional Court held that no choice is available to an organ of state wanting to have its own decision reviewed. PAJA is simply not available to it, and instead the principle of legality is in such instances, is the order of the day. Now, as I've said, this case has been the subject of vociferous academic criticism, and as I noted, even some members of the Constitutional Court bench themselves have ex post facto, after the fact, expressed doubts about its validity and credibility, correctness. Now, what struck me as being the most disconcerting is the fact that a certain aspect of the judgment rests, as it does, on a very narrow, very dated approach, as I said at the outset, to constitutional rights, which is entirely out of step with the actual wording of not only what I said in relation to Section 8 of the Constitution, but Section 38, which deals with the provisions on standing, and it's very wide indeed. So it's completely out of step with Section 38, and it creates in the main a huge anomaly. And this is the anomaly, and I think something that the literature, academic literature on point, has perhaps, given this, there are so many issues with the reasoning in this particular judgment, not hammered home sufficiently as being the main problem. The main problem, to my mind, is the following, and I put it as follows. If Action A, which is administrative action, as defined in the PAJA, is reviewed by an affected party other than an organ of state, say a disappointed tenderer, then it is subject to the stricter procedural requirements of the PAJA and, of course, the Act's more searching substantive review grounds, which I spoke about in relation to legality and rationality review the other night in my last podcast. But if that very same action A is the subject of what I here call Gajima-esque state self-review, this is now a species, it's become a thing, state self-reviews, it will then be subjected to an overall lower standard of substantive scrutiny, but also looser procedural requirements. So here's the rub. In other words, the outcomes in the cases, both flowing from a challenge to the same action A, depend on the identity, potentially, of the party bringing the review. Is that not bizarre, right? Because they are arguably more reaching substantive review grounds under the PUDGER, that's certainly how it's intended, compared to legality, rationality review proper. There are stricter procedural requirements under the PUDGER than there are when it comes to legality, rationality review. And so the outcome can turn on who brings the case, right? Rather than the extent to which the administrative action was deficient in terms of the standards set out in the PUDGER and our Constitutional Court jurisprudence and the Constitution itself. This nonsensical result in turn adds to the uncertainty and the unpredictability of our system of administrative law, with its idiosyncratic profusion of pathways, causes of action, again don't conflate the two, and its variable grounds of review, depending on how the claim is couched. I said here, along with Professor Corder, well, we have yet to see how the courts are going to grapple with this anomaly and the divergent standards in the context of state self-review under legality. For present purposes, we thus highlight briefly several key cases in which legality cum rationality review proper as the backstop for reviewing public power outside the ambit of administrative action has been invoked in relation to the cases I discussed the other night, the duty to give reasons, procedural rationality, procedural fairness, and the prescripts of lawfulness, in particular also proportionality or justifiability, as was called under the interim constitution when I spoke about the Similani judgment. Now, I just did a quick search for recent case law dealing with Gajima, and this case popped up. It's an SCA judgment in Transnet, SOC, it's a state-owned company, as you know. It's also an organ of state within the meaning of Section 239 of the Constitution, versus Tipcon Pty Limited. I hope you can see the judgment okay in this dappled light. And it was handed down on the 31st of January last year. Now, in the article, which I penned with Kachalia back in 2020, Refining the Justice and Equity Remedial Framework, let me sum up what the essence of that article was really about. It started, in fact, as a legal opinion that was provided to a disappointed contractor who was left at the whim, as is so often the case, of a recalcitrant state enterprise. The article has since gained tremendous traction. It's been harnessed by practitioners to vindicate the rights of parties who contract with the state in good faith and whose contracts are then subsequently set aside. And that's often due to the state's failings and the outcomes of these so-called ex post facto state self-reviews. What the article does is it theorizes a sensible way in which to ensure redress for these aggrieved tenderers, while at the same time balancing the need on the one hand for legality, because we recognize that certain irregularities are so egregious that we need to vindicate legality and set the relevant contract aside, but also the need for certainty, right? How do you advise your clients on whether or not they should go for a tender with the state, in which a state, of course, is committed to the rule of law? And the article calibrates various factors that ought to be weighed in the balance, having traversed expansive case law, but in which the factors are a little bit all over the show. What is done in this article is that they are carefully recalibrated and they are done through the lens in the main of impact. And it's a three-pronged impact. And that has been adopted by the courts. It's been cited by the courts, and I'm delighted to see, even though they don't cite us specifically here, that in this Transnet judgment, they make direct reference to the factors as presented in the article. So in this particular case, what happened here was Transnet called for tenders. They needed a tenderer to erect a particular fence, manufacture, supply and install a high security fence at Transnet's City Deep, Camp Cascon and Casnet premises, because there was crime at the premises. And the tender was awarded to Tipcon, and then concluded a contract, and as typically is the case, the relevant private party, in this case Tipcon Pty Limited, begins implementing, as it should, on the contract specific performance and erects the fence. During the installation, there is then a disagreement, and the state party says, oh, but hang on a second, the sample fence that was part of your initial tender did not meet the bid specifications. In particular, it was something to do with, let me see how they term it here. Oh, it had to be hot dip galvanized. Okay, so what happened, and you can read the facts, and as always, they make for very interesting reading. But within the contract, as is often the case, you know the orthodox position is that public law governs up until the award of the tender, whereafter a contract is concluded, and then the default position is that the parties regulate their behavior in accordance with the contract. That is established and well established in our law. For example, the Loughborough Judgment, Cape Metro Inspection Services, of course there's a gloss to that, and we can deal with that at a later stage. Now, Transnet at some point decided that actually they were not happy because this tender had been awarded and the sample provided pursuant to the request for proposals was not hot galvanized. Now, Tipcon launched an application in the Gauteng division of the High Court because they were successful by virtue of a contractual provision pertaining to internal dispute resolution and adjudication, and the adjudicator found for them, and they wanted to have that order made an order of court. So what does Transnet do? Transnet runs off and says, we're going to state self-review our original decision to award the tender to Tipcon. Now, their review was based on 3 grounds. First, they say there was a non-compliant sample, wasn't hot dip galvanized. Secondly, and they say then the second and third grounds were basically that the contract that was concluded between the parties after the tender was therefore not lawful, right? And it was a precondition that the fence erected comply with the tender specs, and the sample provision, the sample extract of the fence did not comply therewith, and therefore the tender was unlawful. So please, court, set aside our tender, state self-review. Now, given the prelude in relation to Gajima, you know that this is now a state self-review, sitting with this constitutional court precedent, which unless until overturned remains binding law. And as I alluded to in my earlier literature, it remains to be seen how the courts are going to grapple with this. And I also alluded to the Allpay judgment and Frenneman's careful distinction between procedure. Matters of procedure typically come first. Do you have the requisite standing? Have you not delayed? Are you in the appropriate forum with the relevant jurisdiction? And then the courts get into the substance. But in order to deal with the anomaly of Gajima, what the courts have had to do is get around it by looking at the substance first before they deal with the procedure. In other words, the substance informs the procedure. So typically speaking, if you delay unreasonably or you do not meet the requirements, the time bar requirements set out within the PAJA, you're out of court. We're not even going to look at the merits of the review in question, right? Because that's how it works, right? You first go to pass the procedural hurdles, and thereafter the court will consider the merits. But now we sit with Gajima, and what happens is that because of the fact that this judgment says, well, hang on a second, if it's an organ of state reviewing its own decision, it doesn't go via the PAJA, it goes via legality. There are no strict time bar delay rules, as I said, and therefore the organs of state in question can dilly-dally, and that is of course potentially hugely detrimental not only to the relevant tenderers but arguably to the public at large that require the services in question. So in theorizing the factors in the article that I referred you to, which you may wish to have a read of, we sought to kind of basically guide the courts here on how they should exercise their remedial discretion. That's why I commenced this podcast with Section 172 of the Constitution. We need to ensure that the discretion, albeit one based on a variety of factors, is judiciously and sensibly exercised in accordance not only with the requirements of legality, but equally that of certainty, such that we can regulate, the state regulates its behaviors with a requisite degree of consistency, clarity, accessibility, so that lives can be planned and business can run, and we can proceed on the basis that anarchy will not reign, and we know that when we sign a contract with the state, that it will be implemented, and so on and so forth. Now, the High Court did not apply what has come to be the developed approach since Gajima. This was dealt with in Buffalo City, which is also traversed in the article I referred you to, as well as ensuing jurisprudence and all the jurisprudence. It was a vast literature review that was done for that article on refining the justice and equity remedial framework in the South African Law Journal of 2020. Those factors, and all of those cases feature in these judgments. So basically, but again, those cases didn't categorize them and didn't systematize them, and so I think it was rendered increasingly difficult for courts to ensure consistency of outcome and/or application. So basically, I'm not going to stress you out too much about the facts, but they make for amusing reading, as these state self-review cases typically do. Essentially, there were several bidders. In this case, there were 7, and TIPCON said in its tender response, look, we haven't hot dip galvanized our sample. They said because why? They gave a reason. Due to the time, we've got the factories closed. It's holiday time, but of course the actual panels and fixtures will be hot dipped and galvanized on fabricated steel, and they give a reference, and this is a paragraph 12 of the judgment. And Transnet accepted this explanation, right? Logical. So they said that's fine. They then unanimously rated TIPCON's tender sample as being substantively responsive. In other words, it met the requirements to the RFP, the request for proposals. And there was a tender evaluation report, and only TIPCON and another company were compliant. Now, despite passing that initial technical evaluation, the other party, CC, was disqualified at the level of functionality, okay? Because you've got to be fully compliant for functionality purposes, and in this particular case, the relevant tenderers had to be registered, as they typically do when it comes to infrastructure, with the Construction Industry Development Board. And this was not done, and that's a material requirement, because what do boards generally do? Well, they ensure things are done properly, right? So there was no registration there, and that's problematic. So you're already out of the game. And therefore, as a result, TIPCON was recommended as the highest ranked bidder on the automated scorecard, and they said, please come ahead. They were authorized to negotiate with the state, with Transnet, and that was in fact requested. And so permission was granted, and there was a meeting of this tender negotiation, which then happened. There was some bantering as to the price. TIPCON came down considerably in its price. In fact, it reduced its initial price by nearly 5 million rand, and yet it stated that it was still offering the highest quality steel welded wire mesh fencing with a 4mm wire diameter using the H-beams, blah, 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 blah. And of course, this was all approved by the relevant acquisition council. The bid transactions ensued. They negotiated the terms and conditions, the contractual conditions, and TIPCON was appointed. It accepted its appointment. There was a kickoff meeting, and they were even told that the project was to be expedited. Remember, it was about security, so it's obviously quite urgent to get this fence up. So Transnet then advised TIPCON, please, initiate things, give us lead times as to the material supply. And they instructed, and I in fact circle these words at paragraph 16. I don't know if you can see my circles in the dappled light, but they instructed TIPCON to construct, right, the samples. They examined them. They said they attended the site for construction, the construction site for inspection purposes, and said, yes, great, perfect. You meet the requisite specs, galvanized, the whole shebang. Yes, cool. There's full compliance. And so, at the bottom of paragraph 16, TIPCON was instructed to procure the materials that were necessary for the construction of the selected sample. Okay, and so you can proceed. And then there's formal approval from Transnet once they're satisfied on the 21st of October 2019. All the tests are performed, an email is sent to DIPCON, and it provides a document, and it then starts doing its thing, and it starts submitting invoices. Now then, there's a risk reduction meeting that is held sometime later. So remember, these negotiations and emails and responses were all happening in 2019. Now in 2020, there is a complaint about the installation. The acting chief engineer of Transnet says, oh, but hang on, what's been installed here is not the same as the sample that was put forward in the bid, right? In other words, as I said, it was not hot, it's galvanized. Now, I hear you scream de minimis, right? Because the ultimate, there was an explanation as to why. Factories were closed, couldn't do that, explained that they would comply with that, reduce their price, and the ultimate product meets the specs, and there was no other compliant tenderer, right, on functionality alone. And so, one moment, I'll see you there. And so TIPCON therefore goes to the adjudicator, as I said, which rules in favor of TIPCON, and it is then Transnet gets upset, and it seeks this state self-review. And this is an appeal from the High Court decision, and mainly it's an appeal on the merits insofar as the High Court does not properly get the two-stage approach to dealing with this conflation between remedies and merits in relation to state self-reviews correct. And that's why this case is important, because it shows you the slippage that's been created by Gajima and how the courts are seeking to find their way around it. Okay, so at paragraph 26, the court discusses delay in bringing the review application. The principles governing delay in state self-reviews are now well established. The court assesses delay according to a two-step analysis. In step one, the question is whether the organ of state unreasonably or unduly delayed in bringing the review. If not, the court proceeds to the merits. So if there's no unreasonable delay, we carry on, we go to the merits. Remember, still under legality rationality review. However, if the delay was unreasonable, then the court proceeds to the second step, and this is where we see a confluence between merits and process. Should the unreasonable delay nevertheless be overlooked? That begs the question, how egregious is the illegality? How material is the shortcoming of the administrative action in question, be it due to legality, procedural fairness, reasonableness, etc. Then in paragraph 27, we know there's no fixed period within which to bring a legality review, which is why Gajima is so bizarre, and why should organs of state be subject to a more lenient standard? Surely they should be subjected to a more searching and exacting standard. Of course, them being public servants that must advance the public interest and do so timelessly and efficiently, and they must fulfill their obligations as such. That's in section 237 of the Constitution. So the High Court said no, Transnet was aware of the non-compliance when TIPCON submitted its tender sample, and they accepted the reason therefore, and so they dilly-dallied 20 months before bringing the state self-review to the High Court, and that was unexplained, and they dismissed it, and they didn't take it further. And the appeal court, the SCA, sees the value in taking it further. And I think there is value in taking it further here, because they then proceed to the second step, right? So the High Court failed to consider whether the delay should nonetheless be overlooked. You have to consider that. They go hand in glove. And ultimately, the SCA feels that the delay was such that it could not be overlooked, right? But why? This is, again, where the courts go into a high-level scrutiny of the merits. And you will see from paragraph 40, should the delay be overlooked, it is trite that for the efficient functioning of public bodies, a challenge to the validity of their decisions by judicial review should be initiated without undue delay. In ASDA construction, it was emphasized that the approach to overlooking a delay in legality review is a flexible exercise where we consider a number of factors. And again, this is where the article penned by myself at Kachalia has been cited, and the various factors that we set out there. So, for example, potential prejudice to affected parties, the possible consequences of setting aside the impugned decision, the nature of the impugned decision. I mean, are we talking about a decision that is so vital? It's about removal of toxic waste from hospitals, and if that doesn't proceed, notwithstanding the irregularity, there'll be a serious public health crisis. Or are we dealing with something relatively minor? And this, of course, requires looking at the nature of the impugned decision, as the court here says, it essentially requires a consideration of the merits of the legal challenge against that decision. Also, the conduct of the applicant, another thing that Kachali and I allude to, taking into account that an organ of state, and this is again something we emphasize, is in fact subject to a higher duty to respect the law. That comes from the seminal Constitutional Court judgment of Kurland, in which Cameron famously said that when it comes to the state, when it comes to government, it has a higher duty. There's a lovely line in that judgment about the state not being an indigent litigant adrift on a sea of litigation. It is the people's primary agent, and it must do right, it must do so properly. Lovely quote. And quite so, it should know what it is and is not expected of it. And then the court gets quite amusing here. It talks about the Latin principle, de minimis non curat lex. In other words, the law does not concern itself with trivialities. Please don't waste the court's time, public resources, litigating like this. It's almost smacks to an extent of, I would say, bad faith, although that's not mentioned. And again, the court goes on to say, you know what, your arguments on the merits are completely without merit, right? You were told why they couldn't produce the sample. You agreed thereto, that there were site inspections, you were satisfied with what was produced, the ultimate product meets the relevant specifications, it's fit for purpose, and the request for proposals itself contemplated that there would be negotiations even after the tender award. You recognized this yourself in your letter, which you sent to TIPCON, and so in fact there can be no complaint that there was a breach of the procurement prescripts as set out in section 217 of our constitution. And then, in any event, and this is where the question of materiality comes in, it comes in so often in constitutional and administrative law. Paragraph 46, in any event, as all pay, which I alluded to at the outset, explains, not all deviances from the requirements of a tender are material and therefore require a declaration of invalidity. And that is important. Remember I said to you that the courts must declare law conduct inconsistent with the Constitution to be invalid. But there is a materiality concern that features there. And this is where the Frenneman two-pronged approach is very useful in the Orpé set of judgments, because he talks about the materiality of the deviation. So think, for example, here, where you explain why factories are closed, you show them exactly how you're going to ensure the meeting of the specifications, the ultimate product meets those specifications, and the state party fully agrees with your approach and wholeheartedly adopts it. And then turns around at the 11th hour and says, but because the actual bid didn't comply, even though the product complies, we now want to set it aside on the basis of illegality. It's just not a material deviation, right? Transnet was indeed supplied with a fence that was hot dip galvanized. Transnet was itself satisfied with the superior quality of the fencing it chose. Transnet secured the benefit of the superior fencing without any additional cost. Remember, I alluded to the substantial reduction in price that TIPCON offered. So, I mean, basically, and there were no other parties that have been unfairly prejudiced in the process. Therefore, to the extent there are deviations, they are immaterial. And then the court looks at prejudice. And as I said, those three categories: the state organ, the successful bidder, and the public at large. We're not talking about, mass awarding of social grants. We're not talking about toxic, waste and the public health situation. And the court says it is incomprehensible that Transnet could suffer any prejudice when it solicited bids for the supply of a 3mm fence. It ultimately contracted for exactly that. It did so after inspecting the erected samples, and it pronounced the selected fence to be superior. And then, again, at paragraph 53, as alluded to in our article of 2020, it's important to look at the way in which the organ of state itself behaves. So from paragraph 53, the court looks at Transnet's conduct in the matter. This is an important factor as to whether or not a court will overlook a delay or not. Transnet not only delayed unreasonably, but it acted in an unreasonable manner. It did not adhere to the constitutionally prescribed standard for state actors. It did not respect the rights of TIPCON. and it refused to recognise the outcome of an adjudicative process in which it had voluntarily participated. Remember, that was part of the contract. In fact, in the adjudication before the adjudicator, Transnet sought to enforce the very contract it now seeks to annul. The only issue was the fence's alleged lack of hot dip galvanization in the wire diameter, and the adjudicator rejected both issues. And then the court goes on to quote other cases, that relied upon in that article, one of which is Tshwane Metropolitan Municipality, a judgment by Ponan AJA, where he talks about materialities, the materiality of irregularities. Perfection is not demanded. Not every flaw is fatal, nor does every flaw in a tender process amount to an irregularity, much less material irregularity. Public contracts do not fall to be invalidated for immaterial or inconsequential irregularities. Indeed, as it has been put, not every slip in the administration of tenders is necessarily to be visited by judicial sanction. And then goes on the court in the SCA in this case to state, Transnet cannot escape the facts, right? It complained about the tender sample very late in the day. This is cynical state self-review. The purpose of an Ordinance of State self-review should be to promote open, responsive and accountable governance. Transnet is required to promote these goals through its actions. And given the prejudice that has been suffered by TIPCON and the nature, the pathetic nature, it doesn't say that, I'm saying that, of Transnet's complaints, the fact that the irregularities in this case were clearly not egregious, as I've said, and in this case the unconscionable, so I spoke earlier of bad faith, but the term they use here is unconscionable, conduct of Transnet, they cannot overlook the unreasonable delay, and that's why it's not heard. So you see the conflation between merits and process, but you see why it's necessary to get around the anomaly introduced by Gajima. And that is the podcast for today. I hope you enjoy it. I hope it makes some sense of the nonsensical, and wishing you all a lovely weekend. From Lauren Khan. Con Law. Bye.